Number 73, Sinan Guider versus Lydia Hubbell.
Good morning, counsel. I'm sorry.
Before we start on the actual motion, I made Mr. Freeman aware there's a guardian ad litem in this case that was appointed by juvenile court for the custody matter there. She was wanting to be here to provide her opinion to the court. I spoke with her earlier today, and she
help me. I guess I'm a little concerned and advised about what the guardian ad litem would have to do with an order of protection.
Well, the order of protection, the motion that's been filed is to modify the order of protection so that the mother can start seeing the child again. The guardian ad litem has a lot of concerns about any modification, so she did want to be here as a witness.
Well, is she here?
She's not, Your Honor. She got called into an emergency removal this morning, and I asked Mr. Freeman.
Who is the guardian ad litem?
Charlena Pymath.
What's your position, Mr. Freeman?
Your Honor, this is a simple motion to modify an order of protection to conform with the orders of the juvenile court.
Now, we kind of got a misimpression. As far as I'm concerned, my orders of protection supersede anything juvenile court does.
Which is why we're here today, Your Honor.
Okay. Well, I'm not conforming my orders to comply with juvenile court's orders.
It's however the court wants to word it. I'm possibly not saying it correctly. All we want to do is to ask this court to allow the order of protection to be modified so that my client can have parenting time with her daughter like has been ordered by the juvenile court. The case was adjudicated there. I see no reason to have the juvenile court's guardian ad litem come in here. It has no bearing on this matter whatsoever.
I kind of agree with that, except to the extent that if the guardian ad litem, as part of her investigation in representing the child, believes that the mother represents a threat of harm to the child, then it could have some bearing on this. One concern, though, is this is what, the second time this has been on the docket? So it does seem that Ms. Hubbell is entitled to her day in court as soon as possible.
If I may, Your Honor, I understand it's the second time it's been on the docket. Neither of those times is my client's fault. We did not get served with notice that it was set the first time. The time it was set the second time, we entered an agreement. Mr. Freeman and I had entered an agreed order. We didn't think we needed to be here. So when Mother showed up and said she was no longer in agreement with the agreed order, this is the first time that we have been present in court, Your Honor, and known that we needed to be here.
All right, well, y'all give me just a second. I'm looking at the order protection narrative in this matter, so hold on just a second. Mr. Freeman, what's your argument for modifying this? Were you involved in the original order of protection here?
I was not, Your Honor.
Okay. All right.
The juvenile court had a multi-day, multi-month hearing spread out over the course of 3 months. They heard proof from both sides, and they've determined that parenting time is appropriate for the mom.
But now that was my order of protection. This was all before the order of protection hearing on June the 15th of this year, correct?
It was. There may have actually been a portion of the juvenile court hearing prior to that. I know that there was a hearing before a magistrate prior to that.
Okay.
And it went up on rehearing.
I don't know, frankly, I don't know how there could have been a 3 months of hearing over 3 months when I just issued this order of protection on June the 15th. I doubt if it's occurred since then, but even if it did, juvenile court coming along and putting an order down that conflicts with my order of protection, I mean, their order wouldn't override my order of protection. So if it was before that, then the incident that was complained of in the order of protection would have been something that took place since then. So go on. I'll let you go on with the argument.
The hearing was scheduled for a portion of a day in April, a portion of a day in May, and then the hearing concluded with a half-day session in the month of August, which would have been after the order of protection was put down. Like I said, the juvenile court heard it. They have deemed that it would be appropriate for the mom to have parenting time. I don't believe there was any proof that would tend to show otherwise in juvenile court. I don't know what proof was put on here. But I know initially the court's order over there is for supervised parenting time, therapeutic parenting time, to kind of ease the child back into a normal mother-child relationship.
Were these parties ever married?
No, Your Honor.
So this was a child born out of wedlock. Who had previously been the custodian of this child?
Mrs. Hubbell. Miss Hubbell.
That's not correct, Your Honor. She had been prior, but before the order of protection was put into place, my client was the primary parent of the child. And Mr. Freeman can't have it both ways. You can't say the juvenile court order doesn't matter, but that we're here to comply with the juvenile court order. What happened in juvenile court is the juvenile court put down an order saying that their order would comply with the order of protection and would be limited to the order of protection, would only come into place whenever that was removed. The court also kept the guardian ad litem and CASA on the case so that they could continue to work with the mother to make sure that everything was complied with. The mother is here with unclean hands today. She has not complied with the juvenile court order so far. She has not complied with the order of protection in that she's continued to harass the father by posting on Facebook almost daily, if not multiple times a day, Your Honor. If we're going to have any kind of a hearing on a modification of the order of protection, I do think it's appropriate for the guardian ad litem and CASA, if they're available, to be here to let Your Honor know what kind of stipulations they think are appropriate as we're easing into parenting time.
Ms. Hubbell, were you the original primary residential parent?
Yes, sir.
Was before the order of protection, was the primary residential parent modified, and was the father made the primary residential parent?
They asked for a temporary parenting plan. He filed.
All right, you need to listen to my question, please, ma'am. Was the primary residential parent status transferred to the father?
In April of 2019, or 2015, just in April, and she thought it was going to be completed by the end of May.
All right, but the answer to my question is it was. Whether it was temporary or whether it was permanent, it was. Okay, thank you. I'll let you have a seat.
But right before the trial started.
Let me say, I respect juvenile court. They got a lot of hard work to do down there. But I heard the proof in this, Mr. Freeman. I know you're trying to represent your client's interest here. I have to say, though, I had to refresh my recollection about this case. But I do remember it, and I remember the testimony, and the testimony was that this child was exchanged at parenting time when Ms. Hubbell was exercising parenting time. The father had indicated that there was conflict with the mother at the exchange. She was upset. She was yelling at him. He finally got possession of the child And in a short period of time, the mother was at his home, knocking on the door, tapping on the windows. He called the police. They ordered her to leave, and she left temporarily and then sat outside of his home and continued to call him. I'll be real honest. Children have enough problems without having to deal with emotional issues that the parents may be dealing with. This court felt like that the behavior that it saw, the police checked on this child, it was perfectly okay. There was no reason for the mother to be at that house. Child observing that sort of behavior is damaging to them, and I'm not modifying my order of protection. I might suggest that your client may want to go and have an evaluation done or get into some type of counseling, and then that information properly presented to the court may make the court inclined to reconsider its position. But
As a matter of fact, Your Honor, my client has been undergoing counseling. We have a
well,
letter
let me
from...
say, excuse me, this is October.
Yes, Your Honor.
This incident was early part of June or late part of July, if I'm not mistaken. I'm kind of guessing about that. But I'm not going to let her go into counseling for a short period of time and expect we're changing anything. So respectfully, I'm denying your request to modify the parenting time. I would suggest to you that an appropriate way of doing this after your client has experienced enough counseling would be for you to file an appropriate petition, give counsel notice, served on the other side. Y'all do whatever discovery you need to do, and then the court will be happy to reconsider its position. But we're not going to be doing it on a Friday motion docket. It's too important for the child. So I know you're trying to help your client, and I respect that, but this is going to have to be done by petition as far as the court is concerned. Okay?
Thank you, Your Honor.
Great. Ms. Rice, will you prepare an appropriate order?
Yes, Your Honor.
Thank you.